This is Bloomberg Law with June Grasso from Bloomberg Radio.
Time and again, Donald Trump has promised to exact revenge against those involved in the cases against him.
Look, when this election is over, based on what they've done, I would have every right to go after them, and it's easy. And sometimes revenge can be justified, Phil. I have to be honest. Sometimes it can.
And the president appears to be keeping those promises to the FBI. In a highly unusual move, his Justice Department is putting together a list of all FBI employees who worked on the criminal investigations into Trump or the January 6th investigations. So 2 groups of FBI agents are going to federal court to prevent the government from disclosing the names on that list, fearing it could target them for retaliation. January 6 rioters who were pardoned by Trump have already taken to social media to identify prosecutors and agents who worked on their cases.
But I will tell you, now it's our turn.
One of the lawsuits cites these comments by Enrique Tarrio, the former leader of the Proud Boys, who was serving a 22-year sentence before his pardon.
The people who did this, they need to feel the heat. They need to be put behind bars, and they need to be prosecuted.
My guest is national security law expert Brad Moss, a partner at Mark Zaid. He's representing the 7 FBI agents and the FBI Association suing the Justice Department. Brad, tell us what's been happening at the FBI.
So what's been transpiring at the moment with the FBI and the Justice Department is that a set of instructions came down from the White House, pretty much starting from day one, to identify everyone involved and associated with the prosecutions and investigations, not only into Donald Trump, but also everyone who was prosecuted for the January 6th riots and the seditious attempts. The set of prosecutors from the January 6th cases that specifically were on Jack Smith's team that went after Donald Trump, those individuals apparently were already fired without cause, which is something that will likely be subject to litigation. But the more immediate and more widespread concern is that the Justice Department ordered the FBI to compile a list, identify everyone within the FBI, special agents, technical assistants, support staff, forensics examiners, everything, compile a list and send it to the Justice Department to identify everyone involved in any of the January 6th investigations and prosecutions, with the obvious concern being not only this is going to be shared with the Justice Department, but also with the White House, and that these names will be made public. The lawsuits that were filed yesterday, there's 2 different lawsuits, one of which I'm a listed attorney on, are designed to keep those names of those FBI personnel private and anonymous, just like it's always done for government officials who are not otherwise public-facing individuals.
The FBI said it had taken steps to protect agents, including identifying them by employee IDs rather than by name, though I'm not sure how much that helps. And that list has already been turned over to the Justice Department.
So the list of the unique identifiers was already turned over according to the reporting. And the way I at least view the actions by FBI leadership was to try to slow walk things, slow this down. Because yes, the Justice Department can go back into the system and start matching up these identifiers to individual names, but that'll take time. That'll take resources. It's mind-numbing work. And there's a question of how much time and resources the Justice Department wants to put into doing that. So part of this was the FBI just trying to slow walk it, but part of it was also a recognition, no doubt, by the existing leadership that if they did not comply in some manner, the White House would simply order them purged, and they would continue purging leadership officials until they found someone willing to comply. Think of, the Saturday Night Massacre drama from the 70s, and ultimately Robert Bork implementing orders for no other reason than to just stop the bloodletting. So that's where things stand at the moment. But even with those identifiers, and even if the Justice Department identifies the individuals from those identifiers, no action has been taken to publicly disseminate that information, and we're working to make sure that does not happen.
The acting director, Brian Driscoll, in a memo, said the list covered thousands of FBI employees around the country, including him.
And by the way, in a memo today, Deputy Attorney General Emil Bove accuses Driscoll of insubordination. I'm sure that'll find its way into a lawsuit. So, Brad, did all the thousands of FBI employees fill out that detailed 3-page questionnaire they got, which included questions about their specific role in the January 6th investigations?
So that was the questionnaire that was originally going to be used to identify everyone involved. And our understanding is basically that majority of FBI leadership told rank and file that they were going to handle it, not to have the individual employees fill this out, and that the various special agents in charge and the assistant special agents in charge and agency leadership took it on themselves to collect the data and to provide those unique identifier numbers to DOJ. But this remains the concern: is what is the purpose of this? Where are they going with this? And what is the White House plan to do with this information? Because remember, one of the first things Donald Trump did was pardon everyone convicted for their actions tied to January 6th, including the Proud Boys, including the Oath Keepers, all these violent militants who had gone in with a plan to take down the government to install Donald Trump after he lost in 2020. Those individuals are now publicly threatening the FBI officials who went after them and who investigated them as part of those prosecutions. And there's a real threat to those FBI officials' lives and their safety and their family members if their names get released.
In your lawsuit, are you concerned about dismissals, or are you only concerned about retaliation?
Right now, this is strictly about keeping the anonymity of the names of these various officials. Because no other action has been taken to actually fire these personnel, we're not there yet on bringing a challenge to it. It's premature. If DOJ does go through with that, if there is a mass purge of personnel, our lawsuit could obviously be amended and updated to address that as well.
Let's talk about the grounds for your suit. Are you suing under the First Amendment and the Federal Privacy Act?
So, the First and Fifth Amendment constitutional protections, due process for these individuals, particularly the stigma of being defamed, essentially, and accused of miscarriage of justice by the White House if their names are publicly released. First Amendment retaliation in the sense that this is all about the fact that they are not politically aligned and ideologically aligned with the White House, which for civil servants is not something they're supposed to be doing. They're not supposed to be political. But also the Privacy Act, which puts strict limits on what agencies can do with the personal identifying information of personnel and where it can and cannot be disseminated absent employee consent, which, to be clear, these personnel are not giving their consent for this personal identifying information to be disseminated outside of the FBI, let alone to the public.
Are you asking for a temporary restraining order?
Yes, a motion for a temporary restraining order was filed yesterday as well, and an initial hearing will be held tomorrow, Thursday morning at 10:30 a.m. in the courtroom of Judge Cobb in D.C.
I'm curious about whether a lot of people from the FBI have approached you with their concerns about this.
Yes, we've been approached by a myriad, an untold number of personnel across the FBI, not just in D.C., but across the country, who we are representing as a part of this collective group. There is a select number of individuals who have agreed to be the plaintiffs in this action. We are keeping their identities protected at the moment. The court agreed to allow them to proceed as John Does and Jane Does for now. We're also working to make sure to try to keep their identities secret from the government itself, sadly, to try to prevent and avoid retaliation for having engaged in this action. But yes, also the FBI Agent Association is also a listed plaintiff, which represents agents across the country and has an obvious organizational interest in protecting its personnel from this political retribution.
Do you think you'll be able to get to meet the high standards for a temporary restraining order?
We do, and that is certainly something we're prepared to start briefing out immediately. That is our understanding, is that the hearing tomorrow, if nothing else, will set out an expedited briefing schedule. We want this addressed immediately. We cannot wait with the way this administration is moving and just this reckless, move fast and break things attitude that Elon Musk and Donald Trump have. Time is of the essence, and every day that passes is another day that these names could be disseminated to the public. So everything is about moving quickly right now to halt any dissemination until these legal issues can be resolved through standard briefing.
There have been accusations from former Trump officials that FBI agents went beyond their authority when they executed the search warrants at Mar-a-Lago. Was there any litigation or court decisions about those accusations?
There is no merit to that. Every challenge regarding the lawfulness of the affidavits, the lawfulness of the searches, did not even fly in motions before Judge Cannon. There has been zero validated claim that these officials went beyond the scope of their authority or otherwise violated Donald Trump's Fourth Amendment rights with respect to his actual property that was at Mar-a-Lago. This is political hatchet job smearing by individuals trying to color it as it being an issue of misconduct. If they had actual verified claims of misconduct against any of these officials, they could bring it through the normal administrative process. They don't want to do that because they know those claims won't hold up to scrutiny.
And so big picture, what you're saying basically is,
these are FBI agents who were doing their jobs, were doing what they were assigned to do.
Correct. And not just, because I don't ever want to go with we were just doing our jobs line, because that harkens back to World War II. These were people following lawful orders to investigate potential crime in the sense of the attack on the Capitol on January 6th, as well as the unauthorized retention of classified documents at Mar-a-Lago. Those are existing crimes. There was a standard investigation. The only quote-unquote misconduct they did was they dared to be part of an investigation into Donald Trump. And the point that this White House is trying to push is that people like Donald Trump and his friends and allies are above the law and can never be investigated.
The FBI, in its many years, there have been controversies. Have you ever heard anything like this, seeking retribution?
This makes you think of, the Hoover days in terms of the idea of such blanket politicization of the Justice Department and of the FBI. We moved beyond that after Hoover for a reason. The civil service and its protections exist for a reason. We're trying to move beyond the flaws and mistakes of the part of our past in this country, not just in the FBI, but in the political system itself. To allow Donald Trump to do what he's trying to do would cripple the existing system and bring us back to the days of Tammany Hall and blanket abuses of power. We cannot go back to that. That is why these lawsuits are being brought. That is why lawyers like us are standing up to protect these individuals.
Finally, during her confirmation hearing, Pam Bondi, who is now the Attorney General, assured senators that she wouldn't retaliate against Justice Department staff simply because they've been assigned to cases involving Trump. Kash Patel echoed a similar pledge. Do you have any faith or hope that now that she's in charge that this might stop?
None. Those promises, those reassurances mean nothing more than the reassurances given by certain Supreme Court nominees about the sanctity of Roe v. Wade. They're politicized, cover your rear end statements that were made to get appointed, to get confirmed, that they will happily, circumvent and throw out the window once they're in power, knowing that there's no one who's going to do anything to stop them. Certainly not the existing majority in the House or Senate. They have no interest in going after these officials if they end up doing what they promised they would not do. And those officials like Pam Bondi know that.
We'll check back with you after the hearing tomorrow. Thanks so much, Brad. That's national security expert Brad Moss of Mark Zaid. The Trump administration has started flying detained migrants on military aircraft to Guantanamo Bay. Last month, President Donald Trump signed an executive order directing the expansion of a migrant detention center at the military installation to full capacity, saying it could hold up to 30,000. Homeland Security Secretary Kristi Noem said the base will hold the worst of those detained for entering the U.S. illegally.
We are building out our capacity at Guantanamo Bay. Right now, that is where the worst are going. We have only a handful of individuals there now, but we will build out those facilities to have a capacity there to meet our needs.
Hundreds of U.S. service members arrived ahead of the detainees to set up a tent city. Here's Marine Corps First Sergeant Johnny Stone.
This is what we train for. We at a moment's notice, we get the call. We were in the field training for something like this, and it happened. We stay ready, and we're ready to go, and here we are.
Immigrant rights groups have warned that moving migrants to Guantanamo would bypass legal protections. So the move is certain to lead to lawsuits. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight, and the former head of the Office of Immigration Litigation in the Obama administration. Leon, Guantanamo is well known, perhaps infamous, for housing terrorism suspects. Has it ever been used to house migrants? How much might this cost?
There have been many periods of time, most prevalently in the 90s under Bill Clinton, where Guantanamo was used as a facility that held migrants. But typically, the way that worked was migrants were detained at sea, and they were sent to Guantanamo so that they were not allowed to enter the United States because there was what was called the wet foot, dry foot policy at that time, which allowed Cubans to, if they entered the United States, they could stay and get lawful permanent residency. So the idea was to interdict the migrants at sea and place them in Guantanamo until something could be figured out if they were actually genuine asylum seekers or if they could be repatriated back to Cuba. And also then Haitians ended up also being detained at Guantanamo. This would be a new phenomenon, which would not be interdicting migrants at sea, but would actually be taking planes and flying migrants from the interior of the United States into Guantanamo, which, yes, becomes a much more expensive operation because you have to have all of those planes flying into Guantanamo. You also have to run the detention facility. You have to move military folks who are not in Guantanamo for the purpose of running a 30,000-person detention facility for that purpose. And so all of that obviously is going to require increased appropriations. But then there will also be legal challenges about things like access to counsel and what they're doing, what kind of individuals are going to be there. Will it only be people with final orders of removal that they're trying to execute removal orders for, which, by the way, also makes things logistically more challenging because then you have to round up enough people from a specific country to put on a specific plane that will leave Guantanamo and go to a specific country. But nevertheless, if it's that, there will be less legal challenges. But if it's people with pending cases, then the question is, how is a lawyer supposed to work with a client who is detained in Guantanamo? And that will provide a lot of fodder for legal challenges.
Yeah, Amy Fisher of Amnesty International said sending immigrants to Guantanamo is a profoundly cruel, costly move. It will cut people off from lawyers, family, and support systems, throwing them into a black hole so the U.S. government can continue to violate their human rights out of sight. I guess you'd expect a lawsuit very quickly?
Yes, I think the complication is going to be the procedural posture of the people being placed in Guantanamo. If they are people whose process has been completed and they have no rights, and the issue is just we want to detain them in Guantanamo to clear up the current detention space we have for people in pending proceedings, then I can see this being able to function much longer than if you're actually sending people to Guantanamo who are in pending proceedings. Because there, I think, unless they provide some very new and innovative ways for lawyers to contact detainees, it's just almost impossible. I don't know how you would represent someone in Guantanamo. It would be very, very difficult to do. And so I think that's going to be a complicated issue there.
Are Trump's threats working? Are most of the countries that weren't going to take back their citizens, are they now accepting them?
Well, the ones that have changed from positions of just maybe, let's say, 2-3 months ago are Venezuela, theoretically. I mean, there's announcements saying that they're changing and they're going to accept U.S. detainees from Venezuela to be repatriated back to Venezuela. And India has also said the same thing, that they would accept people that are going to be deported to India. There was the famous skirmish with the Colombian president, but Colombia was already accepting U.S. removals, and the same thing with Brazil. And so here's the point. To the extent that there have been skirmishes, all of those skirmishes have ended with those countries saying they will accept people the United States is trying to remove. But there are still countries, I mean, the big ones are going to be China and Cuba. Are they going to accept people that the United States is trying to remove? So we'll wait and see on that.
Now, we've talked before about the protections for Venezuelans in the U.S., and the Homeland Security Secretary Kristi Noem says she's going to terminate temporary removal protections for several 100,000 Venezuelans in the U.S. That's like nearly 350,000 immigrants.
Yeah, there are two tranches of temporary protected status because it's just been a sort of scattershot order system that's happened. So there's about 350,000 or so whose status expires April 2nd, 2025. And there's another few 100,000 whose status expires in September of 2025. And what the secretary is saying is that they will not renew the status of the Venezuelans whose status expires in April of 2025, and so they won't have any status. So what does that mean writ large? How will this probably play out? I think probably the way you'll see this play out is a large number of those individuals either already had asylum cases that they actually ended up withdrawing because they got temporary protected status. So they'll have to refile it, and then there's going to be a ton of litigation about whether you filed your asylum claim within the year or you didn't file your asylum claim within the year. So there'll be all of that. You usually have to file for asylum within 1 year after arriving in the United States. So there's that issue. But in the end, almost all of them are going to apply for asylum. And so then what makes this complicated is that's going to create a lot of strain on a immigration court system that already has over 1 million cases in it. And so to the extent that one is trying to create repatriations, one might actually be slowing them down unwittingly by doing something like this. But nevertheless, this is what's going to happen now.
So let's talk about yet another lawsuit against Trump. Immigrant rights groups filed a federal lawsuit against Trump, claiming that his executive order entitled Guaranteeing the State's Protection Against Invasion unlawfully targets asylum seekers with deportation, violating federal law.
So the ACLU, as counsel, filed a lawsuit on behalf of 3 different organizations that work with the refugees. And what they basically said is that the proclamations that were issued by the Trump administration banning all access to asylum in the United States by people who cross the border violates the immigration statutes and violates the Administrative Procedures Act. Basically because the way the statutory authority works, and this has always been the debate about whether one could do this or not, is that the statutory authority says you can apply for asylum regardless of whether you entered the United States legally or illegally. Now, there's a separate part of the statute that says you can ban people applying for asylum if you create a regulatory discretionary reason. So you could add things like, for instance, are a cyber criminal that might not have existed in the 1980s when these statutes were written. So you could do things like that, but the question is, can you use this discretion to take away something that the statute specifically says, which is that it doesn't matter how you enter the United States, you can apply for asylum. And so this litigation was going on under the first Trump administration, then was canceled. Then when Biden put his order in, it was going on. And now this is a new challenge to the new Trump order. But eventually this will work its way to the Supreme Court, and we will see who wins this argument between the two concepts of, can you actually ban asylum as a discretionary matter for people who cross the border, or is that the one area where you're not allowed discretion because the statute specifically says that you can apply for asylum even if you entered the United States illegally?
Do you think that they have a good case, the ACLU?
I think it's a strong case because when Congress actually takes the rare occasion to enumerate something as clearly as that, it does seem like it's a strong case where they wouldn't want the discretion to be used to deny that specific reason for asking for asylum. So I do think it's a strong case. I think, sort of like I say sometimes, a computer judge would probably rule in favor of the plaintiff here. But, since the judges are human beings and they have their own predilections, maybe they will rule for the Trump administration. But I think if you're just using the text and you had these two statutes, one that says you can pick new discretionary reasons to deny people, and one which says that no matter what, you can apply for asylum even if you entered illegally, that you probably couldn't use a discretionary reason that violates that specific statutory instruction that allows you to apply for asylum.
So, I mean, because these cases take so long, is the key here then whether or not they get an injunction to stop Trump from doing this while this is litigated?
Well, here's the problem. The Supreme Court has issued cases during the Biden administration that says now that only the Supreme Court can issue the injunction. The district court and the appellate court do not have the authority to issue the injunction on this kind of removal statute interpretation, just because of the weird, quirky way in which these statutes were drafted, where it actually says that. And so they say, well, I mean, this is weird, but because the statute actually says it, then we're going to interpret the statute the way it says it. And that means that the district court can only basically recommend that injunction and say it's unlawful. And the appellate court can do the same, but it's only going to be the Supreme Court that can issue the injunction, which is why the Biden case took so long, is because you can't actually get a TRO or an injunction to do this now. Now you have to get a declaratory judgment that this is illegal and work your way all the way up to the Supreme Court.
And it's a long way up to the Supreme Court. Stay with me, Leon. Coming up next on the Bloomberg Law Show, El Salvador's offer to jail deportees from the U.S. of any nationality, including U.S. citizens, and the many ways that offer is illegal. You're listening to Bloomberg.
No one's ever made an offer like that. And to outsource at a fraction of the cost, at least some of the most dangerous and violent criminals that we have in the United States. But obviously the administration will have to make a decision.
Secretary of State Marco Rubio said he was exploring whether he could move forward with the offer from El Salvador's president to jail deportees from the United States of any nationality, including U.S. citizens, in El Salvador's prisons, which, by the way, the State Department has described as dangerous and harsh.
Obviously, we'll have to study it on our end. There are obviously legalities involved. We have a constitution. We have all sorts of things, but it's a very generous offer.
And it won't take much studying to discover that sending U.S. citizens to foreign prisons is illegal. I've been talking to immigration law expert Leon Fresco of Holland Knight. Leon, is there any doubt that you can't send American citizens to El Salvador to serve out their sentences?
Right. That is not legal. So first of all, if you were born in America and you're not even a dual citizen of any kind, you would be violating a number of statutes by sending someone to prison in El Salvador. That's just not permitted. But even if the person happened to be a dual citizen, it still doesn't matter. There's no authority. The number one defense in the INA for a removal proceeding is that you're a citizen. That's the sort of, when you talk about rock, scissors, paper, being a citizen is a nuclear bomb that destroys the rock, scissors, or the paper. And so I don't know exactly why that would have been highlighted, other than perhaps to create some sort of feeling of instability for would-be dual citizen criminals to say, hey, be careful, you might get sent to El Salvador, that kind of thing. But in terms of the legality of it, it's very not legal.
I like that term, very not legal. Although President Trump was all for it.
These are sick people. If we could get them out of our country, we have other countries that would take them. It's no different than a prison system, except it would be a lot less expensive, and it would be a great deterrent. It's
possible as a matter of rhetoric, but as a matter of law, I do not think that will end up surviving, both under the immigration laws, under the INA, but also even if you could make some argument that you could legally do it, then the Convention Against Torture would come in. And you wouldn't be able to send people to the kinds of facilities that you're seeing on TV, where you have 500 people packed into one room. That kind of thing is not going to be permitted.
What about sending migrants who are here illegally to prison in a foreign country like El Salvador?
So there are two types of situations where this does happen. First, the U.S. immigration law is actually quite clear that if a person has gone through all of their due process, they can be removed to a third country if the country that's their actual nationality doesn't choose to accept them. And in the past, there have been countries, Venezuela wasn't accepting people. They're claiming that they're going to start accepting people now as of this last weekend. But China has been typically recalcitrant in accepting people. Cuba has been typically recalcitrant in accepting people who are to be removed from the United States. And so there hasn't been a country that's wanted to en masse accept deportees. Now, the problem is there's two layers of this, which is if all El Salvador would do is let the planes land in El Salvador and accept the deportees, that would be a much likelier scenario to survive any legal challenge. The problem is going to be if people start getting detained in some of those famous facilities that you see on the news regarding El Salvador with very violent gang members and things of that nature. People will start filing claims under what's called the Convention Against Torture. And there is a lot of robust case law that says if the facilities are the kind of facilities that resemble the kind of facilities that you see in El Salvador. I don't want to prejudge this, nor do I know which facilities in El Salvador will be used for these contexts, but theoretically speaking, there will be claims that people say, sending me to these facilities in El Salvador is the same as torturing me. And courts will have a lot of litigation there. And so it will be interesting to see if that move actually ends up creating any efficiencies for the Trump administration, or if it just ends up creating a lot of litigation about whether sending people to those facilities violates the Convention Against Torture.
Let's turn to sanctuary cities for a moment.
Trump signed an executive order directing federal prosecutors to investigate and potentially bring charges against state and local officials who don't assist in the administration's campaign of mass deportations. So now apparently there's the first case where they're actually investigating someone in New York. The Justice Department is looking into the release by an upstate New York sheriff's office of an immigrant living in the U.S. illegally. He was released despite an outstanding federal arrest warrant on a charge of illegally reentering the U.S. after a prior removal. So he was arrested by immigration. Ithaca said, well, our police department followed all relevant city policies. That's a pretty liberal city. I mean, what can the Trump administration really do against that local sheriff's office? Anything?
So here is the issue. It's all going to depend on if there are state and local statutes that law enforcement individuals have to follow, which says that you are to release people in detention and in their normal course of action without consulting with immigration because we choose not to consult with immigration, then those individuals will be not prosecutable because they're stuck in a very difficult situation where they would either violate state or local law or they would violate federal law. What's going to be more challenging is if they have some discretion about whether to honor these detainers from the federal government and they choose not to honor the detainer. And then I think you need something plus, like for instance, ICE was outside and they helped them by going out of the back or something, or did some other release that thwarted ICE somehow. In that scenario, you could end up seeing a prosecution for harboring or concealing of someone who's here unlawfully in the United States. But I think it will require more than just lack of cooperation. I think you will need, and I don't think they'll want to make the first case a pure lack of cooperation case if they're being strategic about it. If they're just trying to get any case to scare people, then yeah, they might make any case they want. But if you were being strategic about it, you would do a case where it was lack of cooperation plus some aggravating factor where there was an actual effort of some kind done by one of these state or local individuals to do something in addition to just not cooperating so that an individual could evade detection.
As I've been talking to people in different areas over the last couple of weeks, I've been hearing more and more about senior career attorneys who are experienced in antitrust, who are experienced in environmental law, etc., being reassigned to a sanctuary cities working group. the majority have no expertise in immigration law. I mean, is this a real group?
Yeah, I mean, it's happening in the Department of Justice. There are lawyers even in the immigration sections who are being transferred there that don't ideally want to be transferred there. And they're having to make choices between either retiring or going to this location or resigning. You know, if you're old enough, you can retire. If you're young, your only choice is to resign. And I think there's a lot of people who will not like being transferred either to the Sanctuary Cities Department or to the border for border prosecutions, to the extent that there's lawyers who are working in other cities that the reason they came to the Department of Justice, you have to think of it in three layers. First of all lawyers generally go into the law because they're risk averse. They don't want to go into business or something else. Then if you're at the second level where you go into the government, you're particularly risk averse. You really want to have a stable, normal government job. And now if you're being rerouted places, that just creates a level of trauma for a government lawyer that's far more difficult for, I think, a normal person to understand than for a government lawyer to understand. For a government lawyer, this would be like sending someone who is on a diet to the Hershey factory or something. It just creates a level of destabilization that's unmanageable.
That's the best explanation of why people become lawyers. It does seem like some of them might be transferred because the administration wants them to quit. But for some of them, it's hard to figure out the reason why they want them to quit.
Without getting into this too much, I'll just say there are many different causes for why someone would end up being assigned to the border or to the Sanctuary Cities work group. What I would just say is, to the extent that people don't want to be there, then there should be a weighing process about, is the government actually losing a resource that could be used for some other purpose if the person is just going to leave or not want to be there? And I just don't know what more to say about that, because I tried to keep it non-inflammatory here. So I'll just leave it at that. But I will say that in general, this is not something that government lawyers, it is a huge trauma for them to be reassigned in situations such as this.
So I've been reading a lot about red states following Trump's lead, pursuing sweeping immigration orders themselves. Like Missouri and Mississippi have proposed allowing bounty hunters to detain undocumented migrants and offering $1,000 rewards for tips that lead to arrest. I mean, these are
just proposals as the 2025 legislative sessions power up. Is this helpful to the Trump immigration push?
Are there that many?
This is what's going to be interesting. So there's going to be a lot of this delegation under what's called 287G, which is a section of the Immigration and Nationality Act, which does allow, under certain circumstances, federal officials to deputize state and local law enforcement to do immigration functions. But the problem is there's this choke point. So yes, you can detain people, you can grab them, you can apprehend them, you can detain them, and then what is the question? What do you do now if they're sitting there in a state and local prison for months and months and months, and they can't get into immigration court because there are no judges, there are no ICE attorneys, there isn't the functionality for that. So you have to build the system from that end toward the end of detention rather than from the end of detention, because then you end up with these massive log jams, which will create even more litigation about the legality of doing that and the 287G agreements and all of that. And then all of the government lawyers that are still left in the government are fighting that instead of using their resources to get people legally removed from the United States. And so this is where it's a bit of a resource challenge, because you're trying to get in one area and you're trying to plug one hole, and then another leak opens in another location. And so this is why if you're trying to do a lot of this on the fly, it's going to end up creating leaks in other locations. Whereas what you really have to do is build out the immigration court first. Get that fully staffed and ready to go so that when you get people detained, you can put them through the court. Build up the number of ICE attorneys that are there, so that's the same thing, because you need the ICE attorneys to show up to court and argue for the deportation of individuals. And then you can build up the detention and removal space. and then you would build up the capacity, obviously, in terms of planes and other logistics to get people out of the United States. So that's how you'd have to do it. But again, this is going to require people wanting to be immigration judges and people wanting to go into these fields. And so when you do that, I don't know how many people, A, want to be doing that, but B, with the sort of destabilizations of what it means to be a government lawyer, then, those things create precedents. And so some new administration can come and cancel all of those individuals or move them to environmental protection or something. And so this is the kind of thing that, as people see it, it starts creating challenges in that end too. And so that all of these things are dynamic factors that affect one another, and just we'll have to see how they all play out.
Yeah, Texas Governor Greg Abbott said that he'd signed an agreement with the Customs and Border Protection allowing the Texas National Guard to make immigration arrests. But then, I guess what happens then? So
correct, because arresting them doesn't change anything. You still have to take them through the deportation system in order to actually remove them. And if that system is backlogged and you just have a bunch of people just sitting in a Texas jail, there will soon be lawsuits to get them released from that Texas jail. Yeah. And so that's going to be the interesting question on those cases.
So Texas, there are probably a lot of illegal aliens there. But, I mean, in states like Missouri and Kansas, Indiana, Nebraska, are there that many?
There are undocumented people all over the country. And I think this is actually one of the interesting things I've been grappling with sort of as a policy person, policy adjacent person, a person who used to work as a Senate staffer doing policy, is I've always wanted the solution, now that we're in this very divided red state, blue state country where people can't agree and we're at odds with each other and everybody's at each other's throats. I've been thinking about it, and I've written articles about this, where what you would do is that an immigration bill, that if you did have an amnesty in it, what you could have is a state opt-in, opt-out amnesty. And what that would mean is you could say if a state opted in, then the immigrant could work there legally, but the work permit would be illegal, meaning it would be subject to deportation if you worked illegally in an opt-out state, in a state that didn't want that. And then we could sort of let the laboratory of democracy see which states turned out better. Was it the states that opted in and allowed people who were given the amnesty to work, or was it the states that opted out and created this kind of very draconian enforcement in their state? So we're going to actually, even though there won't be this opt-in, opt-out in that sense, we're going to actually see some version of this happening unofficially when we have a bunch of sanctuary states and a bunch of states that are really hardcore on immigration enforcement. Obviously, we will have a reallocation of where people are, and then we'll get to see for ourselves which states end up doing better and which ones end up doing worse. There's things like agriculture, seasonal labor in a lot of these places. The weirdest places require seasonal labor to do certain things. And so we'll see which ones come out better. And by the way, I'm not convinced that one will come out better than the other. I don't know. But this will be a sort of unofficial way to do it. Now, granted, it will be in a sort of black market economy because these folks won't be legal. So it won't work the same way I would have wanted it to work, where people can work legally. But nevertheless, we'll have to see how this ends up playing out.
Leon, I have to say, this was a tour de force on your part. No matter what question I ask you on immigration, you know the answer. Always a pleasure. Thanks so much. That's Leon Fresco of Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.